Good evening and welcome to Courts Today by Livelaw. This is your host Shambhavi Srivastav bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. You are aware of the Supreme Court decision on electoral bonds and the direction to SBI and Election Commission of India to disclose the bond details. The ECI has disclosed the details of the bonds purchased. The petitioner, ADR, has filed another application to disclose electoral bond numbers in addition to the details already disclosed. Today, a constitutional bench consisting of Chief Justice D.Y. Chandrachud and Justices Sanjeev Khanna, B.R. Gavai, J.B. Pardiwala and Manoj Mishra heard an application filed by the Election Commission during which the Supreme Court has directed the State Bank of India to disclose electoral bond numbers in addition to the details already disclosed. Despite initial reluctance, the court issued notice to the SBI. The court also disposed of the Election Commissioner's application, instructing the data to be digitized and uploaded on the Commissioner's website. This follows earlier directives regarding the disclosure of electoral bond details, stemming from a February 15th judgment declaring the scheme unconstitutional. The court has issued a notice in the application. The Supreme Court has agreed to hear pleas seeking to stay the implementation of the recently notified Citizenship Amendment rules on March 19th. The petitioners argue that the Citizenship Amendment Act is unconstitutional as it links citizenship to religion. According to them, granting citizenship based on religious criteria could be irreversible and unfair. The CAA, passed in 2019, aims to expedite Indian citizenship for non-Muslim migrants from neighboring countries. However, it has faced widespread protest and legal challenges due to its religion-based classification. The government argues that the Act does not affect the citizenship of any Indian citizen, but according to the critics, it goes against India's secular principles. The legal battle intensified after the government notified the rules for implementing the CAA. Various political parties and opposition groups have filed petitions challenging the rules' compatibility with constitutional provisions and agreements like the Assam Accord. The Supreme Court has dismissed the curative petition filed by Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the Delhi liquor policy scam case. A bench consisting Chief Justice of India D.Y. Chandrachud, Justices Sanjeev Khanna, B.R. Gavai and S.V.N. Bhatti dismissed the curative petitions, observing that no case is made out. Sisodia faces charges from the Central Bureau of Investigation and the Directorate of Enforcement. This decision follows earlier dismissals of his bail petitions by lower courts, with the possibility of reapplying for bail if the trial does not progress. Sisodia completed 1 year of incarceration on February 25th. The Supreme Court adjourned the hearing on petitions challenging the new law removing the Chief Justice of India from the selection panel appointing election commissioners. The court deferred the matter to March 21, noting that interlocutory applications were not on record. A bench of Justices Sanjeev Khanna, Dipankar Datta and Augustine George Massey heard writ petitions filed by Congress leader Jaya Thakur, the Association for Democratic Reforms and others, challenging the constitutionality of various provisions of the Chief Election Commissioner and Other Election Commissioners Act 2023. One of the petitioners cited the Anup Baranwal ruling and argued against overturning it. In the case Anup Baranwal versus Union of India, a constitution bench of the Supreme Court has ordered that election commissioners will be appointed by the President of India on the advice of a committee consisting of the Prime Minister and the Leader of Opposition in the Lok Sabha and the Chief Justice of India. The court, however, expressed reluctance to suspend the operation of the Act, citing past practices. The petitioners pointed out the instances of laws being stayed and highlighted the preponement of the selection committee for new election commissioners. The crux of the petitions revolves around the contention that the 2023 Act contradicts a previous ruling, potentially allowing executive influence in the selection process of the selection of election commissioners. This Act replaces the Chief Justice of India with a Union Cabinet Minister in the selection committee. Earlier, a request for an urgent hearing was made following an election commissioner's resignation. Former Congress councillor Balwan Khokar, a convict in the 1984 anti-Sikh riots case, filed a furlough application which prompted the Supreme Court to request a response from the Central Bureau of Investigation. The court deferred the matter for 2 weeks, contemplating whether to refer it to the appropriate authority. Khokar's counsel clarified that the application wasn't based on marriage but on social ties. Despite previously being granted furlough, this time the jail authorities cited a pending matter before the High Court. The court questioned the purpose behind the furlough, emphasizing the importance of social ties. The case originated from the 1984 riots where 5 Sikhs were killed and a Gurudwara was burned following Indira Gandhi's assassination. Khokar was convicted and sentenced to life in 2013, with the verdict upheld by the Delhi High Court in 2018. Khokar had sought relief from the Supreme Court previously, including parole and interim bail due to the pandemic, but his recent application for suspension of sentence was denied. The Punjab and Haryana High Court has stayed the Punjab government's order to supersede the Real Estate Regulatory Authority due to vacant positions in the authority's bench. The government's notice cited Section 82 of the Real Estate Regulation and Development Act 2016, which allows supersession in certain circumstances. However, a division bench of Acting Chief Justice G.S. Sandhawalia and Justice Lapita Banerjee issued a stay on the order, considering the sensitive nature of RERA's functions and the incomplete bench. The court also responded to a PIL challenging the government's order, noting concerns about the vacancies, the hurried nature of the supersession, and conferring power on the governor. The court issued notices to various authorities involved and scheduled further hearings, while clarifying that the stay wouldn't hinder the ongoing selection process for filling the vacant positions. The Madras High Court has recently observed that spreading false allegations on social media to defame innocent individuals is unacceptable. The court directed a YouTuber to pay 50 lakh rupees as damages to Seva Bharati for allegedly making derogatory statements linking the trust with the custodial death of Jairaj and Benix in 2020. Justice N. Satish Kumar further emphasized that freedom of speech does not permit defamation or invasion of privacy. It held that circulating false allegations with malicious intent constitutes defamation and ordered the defendant to refrain from making defamatory statements in the future. The Delhi High Court has issued a restraining order against Ashneer Grover, the former managing director of Bharat Pay, prohibiting him from making defamatory statements against the company or its officials. Justice Pratibha M. Singh directed Grover to take down his tweets, including the one calling the SBI chairperson petty, within 48 hours. Additionally, the court ordered Economic Times to remove an article based on Grover's letters to the RBI chairman. The order has been passed in the defamation suit filed by Bharat Pay against Grover and others, seeking recovery of Rs 88.67 crores and restraining them from making defamatory statements. Grover had previously violated court order and given an undertaking not to post similar content in the future. Grover had previously apologized for his actions, but the court noted his persistent violation of judicial orders. The defendants in the suit, including Grover and his family members, are accused of running a defamatory campaign against Bharat Pay, with the company seeking damages and injunctions against them. The Telangana High Court has dismissed a PIL challenging the release of the movie Razakar, a silent genocide of Hyderabad, because the petitioner failed to challenge the certificate issued by the Central Board of Film Certification. The bench stated that without challenging the certification, no effective relief could be granted. The petition filed by the Association for Protection of Civil Rights alleged that the film could hurt religious sentiments. However, the court noted that the petitioners hadn't watched the movie and couldn't argue whether it contained objectionable content. The movie had been granted an A certificate restricting it to adult audiences. Consequently, the petition was disposed of, with the petitioner advised to seek appropriate legal remedies. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.